Hello, I'm Cliff Eley. I'm an attorney in Colorado practicing in the area of workers' compensation. I only represent injured workers, and I've been doing that for over 27 years. Today I'm going to talk about reopening a workers' compensation case. A workers' compensation case can be reopened anytime within 6 years from the date of the injury or 2 years from the last date that benefits were paid. This means you can reopen your case beyond 6 years from the date of the injury as long as benefits were paid in the last 2 years. But if you're reopening based upon the last date that benefits were paid, you usually can only reopen for more of those benefits. For example, if you are beyond the 6-year reopening statute, but medical benefits were paid in the last 2 years, you can reopen your case, but only with regard to medical benefits. You wouldn't be able to reopen and get more temporary total disability benefits or permanent disability benefits. Reopening is rarely easy, but the best time for reopening is within 6 years of the injury. That way you're not as limited in the benefits that you can receive. Reopening is done by filing a petition to reopen. They can be found at the Colorado Division of Workers' Compensation website. The grounds for reopening a workers' compensation case are change of condition and mistake. Change of condition means that your injury is worsened. Your pain is worse, the injury itself is worsened. For example, if you have a ruptured disc that was repaired and it is degenerated, that's a worsening of condition. Keep in mind that the treating doctor that put you at maximum medical improvement may say that your condition hasn't worsened. If that happens, you may need to get support from another doctor. If the doctor who treated you for your initial injury says that you have gotten worse, then you're in a good position to reopen your case. That doesn't mean that the insurance company will voluntarily open the case. We'll talk about that in a minute. Just because you get it reopened doesn't mean that you're entitled to wage loss benefits, which are called temporary total disability benefits. If you're not working and your condition has worsened, you can petition to reopen your case, but in order to get temporary benefits, you have to show that your restrictions have also worsened since the time that you were put at maximum medical improvement. The reason for this is that the courts have ruled that permanent disability pays you for your ongoing lifelong restrictions. The restrictions have to be worse before you can get lost wages. The other ground for reopening is mistake. This can be a misdiagnosis from a doctor, an advancement in medical treatment that allows someone to get better than they were when they were placed at maximum medical improvement, or it can be a mistake in the doctor's rating. Also, if the workers' compensation law was misapplied, then the case may be reopened. However, you need to remember that reopening is almost always at the discretion of the administrative law judge, particularly when the grounds for reopening are a mistake. The judge can find that the grounds are sufficient for reopening or find that the case doesn't warrant reopening. The judge's opinion on this will probably be upheld on appeal. For this reason, the insurance company rarely reopens voluntarily. They want the case to stay closed, so even in fairly obvious cases, they'll make you go to court. I had a case recently where a doctor admitted that he made a mistake in rating my client. He gave him a 0 rating about 3 years ago. He told the client that the pain would go away over time, but after 3 years of medical treatment and also taking pain medication prescribed by the same doctor, the doctor admitted that he was wrong and that the rating should have been 8%. No doctor disagreed with him. Still, the insurance carrier made my client go to court. They argued that the client should have gotten a second opinion at the time he was placed at maximum medical improvement. My client testified that he trusted the doctor and saw no need at the time to see another doctor. The insurance company's attorney even admitted to me, off the record of course, that the carrier knew that it got away with one on the case. Fortunately, the judge ruled that the worker had no reason not to trust his doctor and that the doctor made a mistake that warranted reopening the case. If you have a question about reopening a Colorado workers' compensation case or about any other aspect of your claim, call me at 303-785-2828 for a free consultation. I'd be happy to answer any questions you have at no charge.